Hi everyone, it's Helen Hotai here, the founder of Form Help, and today we are going to look at the community law website. So go into your browser and type in communitylaw.org.nz, and then we are going to go and have a look at the law manual. So I'm going to click on see all chapters, but you can see to the right here that this is what we are going to be reading, Community Law Manual Online. So we'll go and have a look at all chapters. And basically what I am going to do is I am going to read each chapter. So I will post up each chapter when I'm done. So the first chapter that I have read through is A Death in the Family. So for those of you who don't really like reading, or you can't be bothered reading and you just prefer to listen to someone read it, well, I will be that person, and apologies if you find my voice annoying, but I have recorded this chapter for those who want to listen to it. And also, so I'm purely just reading each chapter word for word. I'm not giving any legal advice or anything like that. And you'll find that as you go through each chapter or listen to each chapter, I'll show you an example. So if I went into confirming and registering the death, and I wanted to look at a specific section of the chapter, just say that you don't want to read the whole chapter, but you just want to hear this section here. So when can doctors and nurses issue a certificate of cause of death? So if you go into the description box below, you should be able to see this heading, and you just click on the heading with the time next to it, and it will take you straight to that reading for you to listen to instead of listening to the whole chapter. Okay, let's get started. Death in the family. This chapter is aimed at helping families in Whanau when one of their loved ones dies. It explains the kinds of things they'll need to do, from making sure all the paperwork for the burial or cremation is completed, to later steps like dealing with the deceased, will and property. This chapter also has some information about how the law in this area can relate to Tangihanga and tikanga Maori. For example, how coroners should take tikanga into account when they're making decisions about post-mortems or autopsies. Confirming and registering the death. In this chapter, we use the term the deceased to refer to the person who has died. When someone dies, the death and the cause of death have to be confirmed by a doctor or nurse, or sometimes by the coroner, before the body can be buried or cremated. In most cases, it will be confirmed by a doctor or nurse who will issue a certificate of cause of death, but if the death was accidental or involved violence in some way, or if the cause of death isn't known, the death has to be reported to the local coroner. They will investigate if necessary, including by ordering a post-mortem or autopsy if one is needed, and confirm the cause of death. As well as this official confirmation of death, there are other documents the funeral director or relatives will need to complete or obtain from others. For example, special approval forms if the body is to be cremated. After the deceased body has been buried or cremated, the death must be officially registered with births, deaths and marriages at the Department of Internal Affairs, who will then issue an official death certificate. This section of the chapter explains these processes and the different documents that are needed. When can doctors and nurses issue a certificate of cause of death? Burial and Cremation Act 1964, sections 46AA to 46B. If a person has died after an illness or some other natural cause, usually the doctor or nurse who has been caring for them will issue a certificate of cause of death. The body can't be buried or cremated without this certificate. This isn't a death certificate, that's the certificate issued by the births, deaths and marriages after you've officially registered the death with them. If the deceased had been ill, the doctor or nurse can't issue the cause of death certificate unless they're satisfied the death was a natural consequence of the illness. Usually doctors and nurses can't issue a cause of death certificate for an accidental death, and instead have to report it to the coroner. but there's an exception when a person over 70 dies after an accident. In these cases, the doctor or nurse can issue a certificate so long as the accident resulted from physical problems linked to the person's age and the death wasn't suspicious or unusual and wasn't caused by someone else. Once the doctor or nurse has issued their certificate, the deceased body can be released to the family so that they can prepare for the funeral. The family can move the body home if they want to, or to a funeral home. Coroner's investigations and post-mortems. When do deaths have to be reported to the coroner? Coroners Act 2006, sections 13 to 15. In some cases, the doctor or nurse who first sees the body will have to report it to the police, who then in turn have to report it to the local coroner. In general, this has to be done if there's something violent, unnatural or suspicious about the death. The body then can't be buried or cremated until the coroner has authorised it, by issuing an order for disposal of body. The coroner's role is to establish when, where, how and why the death happened, and also to work out whether anything can be done differently that might stop similar deaths in the future. Coroners are usually lawyers, not doctors. Here is a list of the main types of deaths that have to be reported to the coroner if the death was suicide or was unnatural or violent, for example, if the person drowned, was poisoned or died in a car crash. The cause of death isn't known. The person died unexpectedly during surgery or medical treatment, or while under anaesthetic, or if they died unexpectedly after surgery or treatment and apparently as a result of it. A woman dies in childbirth or as a result of a pregnancy. The person died in prison or police custody. They died in some other form of official custody care, for example, in a mental health institution, or in a residence run by Oranga Tamariki, Ministry for Children, which has replaced Child, Youth and Family, or a doctor hasn't issued a cause of death certificate, for example, if the person had been ill but their doctor isn't satisfied that the illness caused the death. In these cases, the attending doctor or other officials like the police will report the death to the coroner. If there's been an accident, a car crash for example, the body will be taken to the hospital morgue. This would be arranged by the police at the scene, or if the person died after they got to the hospital, by the hospital staff. The coroner won't issue an order for the disposal of body until satisfied of the cause of death. The coroner may decide it's not necessary to investigate further, in which case a doctor can issue a cause of death certificate and the body can be buried or cremated. What happens when the coroner investigates? Coroners Act 2006, sections 19, 21A and 31. If the coroner decides to investigate the death, they'll take legal possession of the body from the police. The coroner may decide to get a pathologist, a medical specialist in diseases, to do a post-mortem examination of the body, also called an autopsy, to find out the cause of death. To help decide whether a post-mortem is necessary, the coroner may first get a pathologist to do an initial preliminary inspection of the body just by examining the body externally, or by using x-rays, MRIs and similar techniques, or both. In a few cases, the coroner may also decide that an inquest is needed. This is a legal hearing in the coroner's court into the death and its cause. Can family stay with the body while the body is with the coroner? Coroners Act 2006, sections 25 and 26. The coroner can allow the immediate family or whanau and also a minister to see, touch and stay with the deceased body while it's with the coroner. In deciding whether to allow this, the coroner will take into account factors such as whether this could make it harder to find out the cause of death, any health risks to the family, whether there are rooms and facilities available for the family or whanau, requirements under tikanga that whanau need to see, touch or stay with the tupapaku, or other customary requirements under other cultures that family need to see, touch or stay with the body. What is a post-mortem and why might one happen? Human Tissue Act 2008, Sections 49(1) and 54, Coroners Act 2006, Section 36. A post-mortem is a surgical examination of the deceased body, ordered by the coroner to find out the cause of death, sometimes also called an autopsy. It's carried out by a pathologist, a medical specialist in diseases. The pathologist will examine the internal organs as well as the external injuries, although the coroner can direct them to do a less invasive type of examination. The pathologist will try as much as possible not to leave any visible signs of the post-mortem. They have a legal duty to avoid disfiguring the body unnecessarily. These are the factors the coroner has to consider when deciding whether to order a post-mortem. Coroners Act 2006, Section 32. Whether it will reveal useful information about the death, whether the death appears to have been unnatural or violent, and if it does, whether the death appears to have been caused by someone else. Any claims, rumours, suspicions, or public concern about the death, whether a post-mortem could cause distress or offence to the family because of tikanga Maori or other cultural attitudes or beliefs, whether the immediate family has asked for a post-mortem. Coroners Act 2006, Section 37. The coroner can order a post-mortem to be done immediately if there's a good reason. This could be, for example, because delaying it would make it harder to find out the cause of death, because the deceased person is an infant, out of recognition of tikanga Maori or other cultural practices or beliefs that customarily require bodies to be made available to the family as soon as possible after the death. Coroners Act 2006, Sections 23, 24 and 27. When a coroner orders a post-mortem, they have to notify the immediate family as soon as practicable, including telling them why the post-mortem is being done. They also have to tell the family about their right to object. After the post-mortem, the coroner has to give the family a copy of the pathologist's report, if the family asks for it. If the family have questions about the report, the coroner can get the pathologist who wrote it to contact the family and discuss it with them. The family prevent a post-mortem being done. Coroners Act 2006, Sections 33 to 35. They may be able to, in some cases, by lodging an objection with the coroner and then, if necessary, going to the High Court. Any member of the immediate family has a right to object to a post-mortem except if the coroner has decided an immediate post-mortem is needed because a delay would make it harder to find out the cause of death, or it seems the death was caused by a criminal act. Family members have 24 hours to object after the coroner notifies them of the post-mortem order. If they object, but the coroner still wants to go ahead with the post-mortem, the coroner has to notify the family of this intention. The family then has 48 hours to take their objection to the High Court. The High Court has to deal with the objection urgently. You'll need a lawyer to file an objection in the High Court. Legal aid is available for this. See the chapter Legal Aid and Other Legal Help. When will the coroner release the body? Coroner Act 2006, Section 42. The coroner has to release the body as soon as they're satisfied there's no reason to withhold it from the family. They will usually authorise its release by signing an order for disposal of body within 24 hours after any post-mortem. The body can be released to the family to be buried or cremated. If the coroner has decided a post-mortem isn't needed, the coroner has to wait for 24 hours after notifying the police of this decision before releasing the body, although the police can allow the coroner to release it before this. There could also be delays if specialists, other than the pathologist, need to be called in. However, usually the body should be released with no more delay than would normally occur if a doctor signed a medical certificate of cause of death. Notifying births, deaths and marriages so that the death can be registered. Births, Death, Marriages and Relationships Registration Act 1995, Sections 42, 47 and 48. After the deceased body has been buried or cremated, births, deaths and marriages at the Department of Internal Affairs must be notified. This has to be done within 3 working days. If a funeral director is in charge of the burial or cremation, they'll take care of notifying births, deaths and marriages. If you're not using a funeral director, this will be the responsibility of the person in charge of the body, which will be the executor under the deceased will, or if there's no will, the closest relative. See in this chapter, burial and cremation, decisions about the deceased body. You'll need to fill out the special form for this called a Notification of Death for Registration form, BDM 28. To get a copy of this form, phone 0800 225252 or go into a BDM office. They have offices in Auckland, Manukau, Wellington and Christchurch. It doesn't cost anything to register a death, but there is a charge if you want a copy of the death certificate. Getting a copy of the death certificate. When births, deaths and marriages has officially registered the death, they will issue a death certificate. Officially, this is called a New Zealand death certificate. Having a copy of the death certificate can be important, for example, for getting funds released from the deceased's bank when it's only a small estate. See in this chapter, dealing with their deceased property, small estate, no need for court approval. Now, to get a copy of the certificate, you'll need to apply for it and pay for the relevant fee. You can apply when you fill out the notification form. Where to go for support. Confirmation of the cause of death, the coroners. The website of Coronial Services of New Zealand has information about the role of coroners in investigating the causes of death. Registering a death. The Births, Deaths and Marriages section of the Department of Internal Affairs has information on its website about registering deaths, burial and cremation. Local council websites have information about burial and cremation in their particular areas. Financial support for bereaved families. Work and Income's website has information about possible financial support for funerals and Tangihanga. Click on Benefits and Payments, Urgent or Unexpected Costs. ACC's website has information about different types of accident compensation and payments that can be made to family members when a person has died in an accident. Go to www.acc.co.nz and click on I'm Injured / types of financial support / financial support if someone has died. Gathering kaimoana for Tangihanga. The Ministry of Primary Industries has information on its website about Maori customary rights for gathering kaimoana for Tangihanga, hui and other traditional purposes. Organ donation. The website of Organ Donation New Zealand has information about organ and tissue donation. Funerals and Tangihanga. Overview. For information about funding for funerals and Tangihanga, see below in this chapter, Financial Support for Bereaved Families. Arranging the funeral. Sometimes family hand control of funeral arrangements over to a funeral director. However, you don't have to do this, so you and other immediate family may want to be more actively involved in their final arrangements as part of your grieving process. Using a funeral director. A funeral director can take care of the full range of legal and practical tasks involved, including transporting the body, checking that all the legal requirements and documents for burial or cremation are in order, the embalming, care and presentation of the deceased's body, organising the minister or celebrant and other people you might need, like an organist, death and funeral notices, flowers and catering, support services for bereaved family and friends, registering the death. If you're going to use a funeral director, it's best to use a funeral director from the Funeral Directors Association of New Zealand. They have to have appropriate qualifications and experience and must also follow a code of ethics. This requires them to, for example, respect the ethnic origin and spiritual beliefs of the deceased person. Arranging the funeral yourself. Many families also decide to arrange the funeral themselves. If you decide not to use a funeral director, there are some legal requirements you'll need to take care of. Confirmation of cause of death. The body can't be buried or cremated unless a doctor has issued a medical certificate of cause of death, or if the death had to be reported to the coroner has issued an order for disposal of body. Registering the death. Within 3 days after the burial or cremation, you'll need to register the death with births, deaths and marriages. For more details about those steps, see above in this chapter, confirming and registering the death. Embalming isn't always necessary if the body is to be buried or cremated within 2 or 3 days after death. However, particularly if the body is to be kept at home, the family may want to consider embalming. The speed with which the body may decompose will depend on different factors, including the cause of death, any medication the deceased may have been taking, and the time of year. It's best to get advice about this from a funeral director. Some other tasks or decisions you'll probably need to consider can include contacting other family and friends and publishing death or funeral notices in newspapers and online, the form of the service, for example, whether it will be led by a minister, a non-religious funeral celebrant, or a family member, letting people know if the deceased wanted any donations to go to a particular charity instead of flowers, for example. Deciding on a place where people can gather after the funeral. You might want to ask friends to organise food or perhaps organise professional caterers for this. Pre-arranged funerals. The deceased may have decided to arrange and pay for a funeral in advance. They might have left instructions in their will or with family members about what they'd like to happen. These instructions aren't legally binding on the family, but it would be unusual for a family not to follow them. Sometimes people decide to pay for their funeral in advance. The Funeral Directors Association of New Zealand operates a prepaid funeral scheme, where in planning for your funeral you meet with a funeral director to talk about arrangements, and you pay the price of the funeral into a special trust account. The cost of the prepaid funeral, up to $10,000, isn't counted as part of your assets or your property when work and income are working out whether you qualify for a residential care subsidy for rest home care. Tangihanga. Whanau and tupapaku. Release of tupapaku, the body, to Whanau. In most cases, when a person has died, the doctor who looked after them during their final illness will sign a certificate confirming the cause of death, and legally this immediately releases the tupapaku to the whanau. In some cases, however, a death has to be reported to the local coroner, who may then want to do a post-mortem or autopsy to confirm the cause of death. The law here requires the coroner to take account of tikanga Maori and other cultural beliefs and practices in various ways. Coroners Act 2006, Sections 25, 26, 32 to 35 and 37. When deciding whether to order a post-mortem, the coroner has to take into account whether this would cause distress or offence to the family because of their cultural beliefs and practices. The family can also object to the post-mortem and can take their objection to the High Court if necessary. If the coroner does decide a post-mortem is necessary, the coroner can order it to be done immediately to take account of requirements under tikanga Maori or other cultural beliefs and practices for the tupapaku to be released to the family as soon as possible after death. The coroner can also allow whanau and a minister to stay with the tupapaku while it's with the coroner. This recognises the tikanga requirements that whanau should stay with the tupapaku at all times until burial. Disagreements among whanau about where tupapaku will be buried. Takamore versus Clark, 2013. If whanau disagree about where the deceased's body should be buried, the person who has the legal power to decide is the executor under the deceased's will. If there's no will, then this power will usually rest with the closest relative, as the person who has the best legal claim to be appointed by the courts as the administrator for the estate. The executor/administrator has to take into account the views of immediate and wider whanau, and to consider different cultural, religious and spiritual practices. However, they don't have to actively seek out the views of whanau. whānau can also challenge the executor/administrator's decisions in the High Court. Financial support for Tangihanga. What financial support is available to whānau for Tangihanga? Contact your iwi organisation to find out if you're able to get a grant for the Tangihanga. Whanau may also be able to get funding from a Maori land trust or other organisation in which they or the deceased have an interest. To find out about other possible sources of support, contact Te Puni Kōkiri or your local marae or Māori church. You may also be able to get a funeral grant from Work and Income or from ACC if the deceased died in an accident. Gathering kaimoana for Tangihanga and hui. Overview of Māori customary fishing rights. Fisheries Kaimoana Customary Fishing Regulations 1998. Fisheries South Island Customary Fishing Regulations 1999. Fisheries Amateur Fishing Regulations 2013, Regs 50 and 51. The Amateur Fishing Regulations allow anyone to gather shellfish and other kaimoana up to particular daily limits if they're not fishing or gathering commercially. And this might be enough for the tangihanga you're preparing for. For example, the limit for paua is usually 10 per person per day. And so a group of 3 of you can gather up to 30 paua in one day for the amateur daily limits. See the chapter Common Crimes under paua, poaching and other fisheries offences. However, if a tangihanga or hui will need more than those standard limits allow, you can ask local tangata whenua to give you written permission to go over the limits or to use different fishing methods or equipment than would normally be allowed. The detailed rules that apply are slightly different depending on whether or not kaitiaki have been formally confirmed by the Ministry of Primary Industries for your particular harohe or area under the Special Customary Fishing Regulations. Those customary fishing regulations enable local tangata whenua, those who have mana whenua and mana moana over the particular harohe, to appoint particular people to be kaitiaki for that harohe. The appointment of those individuals for that harohe is then formally confirmed by the Ministry of Primary Industries. The appointed kaitiaki can then give written permission for customary food gathering within their role. Fisheries Amateur Fishing Regulations 2013, Regulations 50 and 51. If no kaitiaki have been formally appointed for your particular harohe, you're still allowed to gather for tangihanga and hui under the Amateur Fishing Regulations if you get written permission from a representative of local tangata whenua. For more details, see below how do I get permission for customary fishing and who from. Kaitiaki have been appointed under the Special Customary Fishing Regulations for several hundred different rohe, but there are also many rohe that aren't covered. For example, kaitiaki have been appointed for whakatane and ohope in the Bay of Plenty, but Waiōtahi and Opōtuki further east aren't covered and therefore come under the rules in the Amateur Fishing Regulations. Te Arawa Lakes Fisheries Regulations 2006. There may also be specific regulations that apply to customary fishing in particular rivers and lakes. Generally, these will set out the same sort of processes as the customary fishing regulations. MPI or your local iwi organisation should be able to tell you if specific rules apply in your area. The Fisheries New Zealand website has a map showing all the rohe for which kaitiaki have been formally appointed under the customary fishing regulations. Go to www.mpi.govt.nz and search for customary fisheries management areas. You can also ask Fisheries NZ about this by email on info@mpi.govt.nz. Traditional purposes for which kaimoana can be gathered. If kaitiaki have been formally appointed for your rohe, they can give you written permission to gather kaimoana for tangihanga, hui, koha, or any other traditional purpose that they specifically decide. Fisheries Amateur Fishing Regulations 2013, Regulation 51A. If no kaitiaki have been formally appointed for your rohe, written permission from representatives of local tangata whenua can only be given for gathering kaimoana for hui or Tangihanga. How do I get permission for customary fishing and who from? Fisheries, Kaimoana Customary Fishing Regulations 1998, Regulation 11. Fisheries, South Island Customary Fishing Regulations 1999, Regulation 11. If kaitiaki have been formally appointed for your rohe, you'll need to get written permission from one of them. You can email info@mpi.govt.nz for information about exactly who you can get permission from. If no kaitiaki have been formally appointed for your rohe, you will need to get permission from either Fisheries Amateur Fishing Regulations 2013, Regulation 52, the Committee for your Marae, the local runanga, a local Maori committee established under the Maori Community Development Act 1962, a Maori Trust Board. You will need to keep the written permission with you, ready to show fisheries officers if necessary. What kinds of conditions will the authorisation include? When an official kaitiaki for your rohe gives you permission, this has to be in writing, unless the kaitiaki has formally confirmed some other process with the Ministry of Primary Industries. It must include a lot of detail. Usually it has to say, Fisheries Kaimoana Customary Fishing Regulations 1998, Regulation 11.3, Fisheries South Island Customary Fishing Regulations 1999, Regulation 11.2. The dates it applies to, the names of the people who can gather the kaimoana, the purpose for which the kaimoana can be taken, such as Tangihanga, the particular species covered and how many of each species can be taken, size limits, the fishing methods that can be used, and the particular place where the catch can be used, the local marae, for example. The kaitiaki will set the size limits, catch limits, allowable methods, and so on. They don't have to follow the regular limits and restrictions that apply under the amateur fishing regulations. If you breach any of the conditions, you won't be protected by the customary fishing rules and could face criminal charges. Fisheries Amateur Fishing Regulations 2013, Regulation 51, Schedule 5. Permission granted by local tangata whenua if no kaitiaki have been officially appointed must set out the dates and the areas the permission applies to, and also a catch limit. It can also set down size limits and restrictions on fishing methods. What happens if I gather kaimoana without permission? Fisheries Kaimoana Customary Fishing Regulations 1998, Regulations 41, 42 and 46. Fisheries South Island Customary Fishing Regulations 1999, Regulations 39, 40 and 44. If you gather kaimoana for customary purposes without getting proper written permission from the kaitiaki or local tangata whenua, you can be given an infringement notice, like a speeding ticket, for a fine of up to $500, or in more serious cases you could face criminal charges in court. The same applies if you've got permission but you haven't followed all the conditions. For example, if you go outside the specific areas the permission applies to, or you take more than it allows. In serious cases, you could potentially be given a community-based sentence, like community work or a jail term. Any equipment you used when fishing, like your boat, car, and diving gear, could also be seized and taken from you permanently. For information about the possible charges and penalties for fisheries offences, see the chapter Common Crimes under Paua Poaching and Other Fisheries Offences. Fisheries Act 1996, Sections 199 to 207. Note, fisheries officers who work for MPI have very wide search and seizure powers, and powers to require people to answer questions. Whanau decisions about property. Making decisions about the deceased property at Tangihanga. Te Ture Whenua Maori Act 1993, Section 176. At a Tangihanga, whānau can make decisions about Māori land, which will then need to be confirmed by the Māori Land Court. For more information, see below in this chapter, dealing with the deceased property, Māori land. Burial and cremation. Decisions about the deceased body, legal rights and powers. Normally there aren't any problems or disputes about what is to happen with the deceased body, and so strict legal rights and powers don't come into play. The deceased may well have made clear what they wanted to happen, either in their will or just by telling family and friends, and in that case their wishes will usually be followed. If the deceased didn't tell family and friends what they wanted, then the family will decide together what is to happen. As with other areas of life, legal rights and powers will become important if there's a disagreement about what should happen. In this section, we explain who has the legal power to make decisions in these cases. Who has the right to make decisions about the deceased body? Takamore versus Clark. If the family can't agree on where the deceased is to be buried or whether they'll be buried or cremated, the person who has the legal power to make these decisions will be the executor named in the deceased's will. If the deceased didn't have a will, or if the will is invalid or didn't name an executor, then this decision-making power usually lies instead with the closest family member, as the person with the best legal claim to deal with the deceased's property. When there's no will or executor, the deceased property is dealt with by a relative appointed by the courts as the administrator for the estate. There's a legal order of priority for who the courts will appoint for this. At the top of the list is the spouse or partner, followed by the children, and then parents, sisters, brothers, and aunts and uncles. However, you don't have to have already been appointed administrator to be able to exercise decision-making power about the deceased body. What counts is that you're the one who has priority. Takamore versus Clark and the High Court's Rules 2016, Rule 27.35. The executor/administrator has to take into account the views of immediate and wider family, and to consider different cultural, religious and spiritual practices. However, they don't have to actively seek out the family's views. Note, the executor/administrator is expected to follow the deceased's wishes, but they're not legally required to do so. Burial and cremation. Burial's legal requirements. Documents that have to be completed before a burial. You will need to fill out the local council's application form for the burial and show the council a copy of the certificate of cause of death given by the doctor or nurse or the coroner's order for disposal of body. Where can bodies be buried in New Zealand? Burial and Cremation Act 1964, Section 46. Usually a burial has to be in either a public cemetery, these are run by local councils, a denominational burial ground, these are usually small church burial grounds that cater for a particular religion, such as Catholic or Anglican, an urupa, Maori burial ground, or a private burial ground. However, the body can be buried somewhere else if there isn't one of those cemeteries or burial grounds within 32 k's of where the death occurred or where the body is going to be buried. In that case, the nearest district court has to be notified about the burial, including the cause of death. For contact details for the courts, go to www.justice.govt.nz/courts/district-court. Buying a burial plot. You should check within the family whether their deceased had already bought a burial plot. And as an example, in 2021, a burial plot in the public cemeteries run by Porirua City Council cost $2,260 for an adult-sized plot and $1,055 for a child under 10. A second burial in the same plot costs $1,220 or $575 for a child. You will need to pay for the plot immediately or give the council proof that Work and Income or ACC will pay for it through a funeral grant. See in this chapter financial support for bereaved families. If the deceased qualifies for a funeral grant, contact Work and Income or ACC first so that this can be processed as soon as possible. You should contact the local council at least 24 hours before burial to choose a burial plot, although in urgent cases you may be able to arrange a plot on the same day as the burial if you contact them early on that day. The grave will be dug by the cemetery's sexton, and the cost of this is usually covered in the charge for the plot. Cremation, legal requirements. In New Zealand, cremation is more common than burial. It's been estimated that about 70% of deceased New Zealanders are cremated. Cremations take place in crematoriums run by local councils and by some private operators. Documents that have to be completed before a cremation. Cremation Regulations 1973, Regulations 4.2, 5.1, 7.1, Forms A, B and F. If the deceased body is going to be cremated, you will need the following documents. The certificate of cause of death given by a doctor or nurse or the coroner's order for disposal of body. Take this with you when you go to the local council office to apply for a cremation. An application for cremation, Form A. You will need to complete and sign this at the local council office. You will need to pay for the cremation at the same time. The council will also give you Forms B and F to be completed. A certificate of medical practitioner or nurse practitioner, Form B. You will need to take this new form to the doctor or nurse who saw and identified the body after death for them to complete and sign it. This form gives more information about the circumstances of the death. A permission to cremate form, Form F. You will need to get this signed by the medical referee from the local council or private operator that runs the crematorium, and you will need to show them the completed Forms A and B. The medical referee is a doctor, and their approval is a final precaution that the cause of death has been determined and there's no reason why the crematorium can't go ahead. There's usually a charge for the medical referee services, but this may already be included in the cremation fee. You will need to give all these completed forms to the crematorium manager or sexton on the day of the cremation. Paying for the cremation. You will need to pay the council the cremation fee immediately or show them proof that Work and Income or ACC will pay for it through a funeral grant. See in this chapter, financial support for bereaved families. In Porirua, for example, a cremation costs $540 for an adult and $350 for a child aged under 11. Donating organs, who decides? Overview. While decisions about your burial or cremation are made by your personal representative, the executor under your will, or if you don't leave a will, your closest relative, a different legal framework exists for organ donation under the Human Tissue Act 2008. This act gives priority to any informed decision you made while you were alive, but allows your family to give consent to or object to organ donation if you hadn't made any decision. In this area, the personal representative plays only a facilitating role, not a decision-making one. Note: another step you could consider is to make an advance directive about future medical treatment should you lose the ability to make decisions. These are sometimes also called living wills. For information about this, see the chapter Disability Rights under Agreeing to Treatment or Services, the issue of consent. Summary of decision-making hierarchy. Human Tissue Act 2008, Section 31. The Human Tissue Act sets up a hierarchy of people who can give legally valid consent or make a legally valid objection about organ donation. At the top is the deceased person. The doctors will first need to find out if the deceased consented or objected to organ donation before they died. If the deceased hadn't made any decision and hadn't appointed someone to decide for them after their death, then the immediate family decides together. If there's not a decision from the immediate family, then any close relative can decide, but their consent can also be overridden by another close relative. However, although the deceased is formally at the top of this hierarchy, in practice things are different. The Human Tissue Act lets the doctors decide not to act on consent given by the deceased, and doctors have usually always used that freedom to choose not to go ahead with organ donation if the family oppose or are distressed about it. Note: unlike some other countries, New Zealand doesn't have a national register for recording people's consent to being an organ donor. Driver's license information is the closest thing we have to a register, but having donor on your license doesn't of itself count as giving informed consent to organ donation. This just indicates to medical staff that you're a potential donor, and from there they will ask your family if they know if you had clearly given or refused consent, apart from your driver's license. In the same way, saying no to being recorded as a donor when you apply for your license or renewal doesn't count as an informed objection. First level, a decision by the deceased. Human Tissue Act 2008, Sections 14, 16 to 18, 31 2a. The doctors will ask your family if they know what your views were about organ donation. If you had given informed consent by recording it in writing or telling 2 witnesses about it, a driver's license doesn't count. That gives the doctors the legal power to use your organs. But if you had decided you didn't want to be an organ donor, again by writing down the decision or telling 2 witnesses, then that stops everything and the doctors can't use your organs. Although your informed consent allows the doctors to go ahead with organ donation, they're legally required to take into account their views of your immediate family or whanau and their cultural and spiritual needs, values and beliefs. If your family aren't happy with your organs being used, then in practice the doctors almost always treat their wishes as most important and don't go ahead with donation. The family can't legally override an informed decision that you had made to not be an organ donor. However, simply choosing not to have donor on your driver's license doesn't count as an informed objection. So legally, the family can override that and give valid consent to organ donation, and the doctors can act on that consent. What's recorded on a driver's license doesn't have any legal status as a record of your wishes. It's only a general indication that you're a potential organ donor. If your family aren't aware of any decision you'd made about this or of you choosing someone to make decisions for you, a nominee, then the decision is up to your immediate family or whanau, or if they can't agree, on any of your close relatives. Human Tissue Act 2008, Section 15. Note: if the doctors approach your personal representative, your executor under your will or your closest relative, for help in finding out about any decision that you or your family has made, the personal representative must do everything reasonably practicable to help. Second level, a decision by the deceased nominee. Human Tissue Act 2008, Sections 31 2b and 39. If you had appointed someone to make decisions for you about organ donation after your death, called your nominee, then that person's consent or objection counts the same as if you had made a decision, so long as the nominee's decision is an informed one and meets the other rules that apply to consent and objections under the Human Tissue Act. You have to record or communicate your appointment of a nominee in the same way as for consenting or objecting yourself, that is, by writing it down or telling 2 witnesses verbally. You can appoint more than one nominee. In that case, the standard rule is that your nominees all have to consent together in order for their consent to be valid, but that an objection from any one of them will count as a valid objection and prevent organ donation going ahead. However, you can specify different rules about this when you nominate them. For example, you can decide that any one of them can validly consent or object, or you can decide that any consent or objection has to be by all of them to be valid. Human Tissue Act 2008, Sections 37 and 38. People under 16 can't choose a nominee. If you're under 16 when you die, your parents or guardians will make decisions about organ donation. Protection of Personal and Property Rights Act 1988, Section 106. Note: any person to whom you've given an enduring power of attorney won't have power to make decisions about organ donation after you die. This is because the attorney's power come to an end on your death. For more detail, see the chapter Decision Making and Powers of Attorney. Third level, decision by immediate family or whanau. Human Tissue Act 2008, Sections 31 2C, 35 and 40. If you hadn't made any decisions and hadn't appointed a nominee or your nominee isn't available, then the doctors will need general agreement among your immediate family to be able to go ahead with organ donation. The consent is given by a single member of your immediate family on behalf of the rest of the family. That person has to do everything that's reasonably practicable to consult with and get general agreement from family members who represent all the different interests of the immediate family. That family member can only consent or object on the immediate family's behalf if he or she believes on reasonable grounds that all immediate family members agree with this, or would agree if they were consulted personally. Your immediate family includes your spouse or partner, children, parents, grandparents, brothers and sisters, stepchildren, stepparents, and stepbrothers and stepsisters. It also includes any other member of your family, whanau, or other culturally recognised group who either was in a close relationship with you or had responsibility for your welfare according to your community's customs and traditions. Final level, decision by a single close relative. Human Tissue Act 2008, Sections 9, 3, 10, 31, 2D, 36 and 41. If there's not a collective decision from your immediate family, or if it would take too long to get one, the doctors can act on consent given by a single close relative. In the same way, an informed objection from any close relative stops the process, even if another close relative has already given valid consent. A close relative means your spouse or partner, or if you didn't have a spouse or partner, then any of your children who are 16 or older, or if there's no spouse, partner, or children who have turned 16, then one of your parents, or if there are none of those people, any of your brothers or sisters. If you're under 16 when you die, then a close relative means one of your parents, or if your parents aren't available, any brother or sister who's 16 or older. Note, it's a criminal offence for medical staff to use a person's organs if the proper consent hasn't been given. They can be jailed for up to 1 year or fined up to $50,000. Human Tissue Act 2008, Section 22. When consent to organ donation is valid. Consent or objection must be free, informed and specific. Human Tissue Act 2008, Sections 9 and 27. Your decision must have been given freely, and it must also be an informed decision, which means you have to have all the information that a reasonable person would need in your situation. The kinds of information you'd need would probably include things like what the process would be for confirming that you were in fact dead, how your organs or other tissues would be used, the effect the transplant procedure would have on your body's physical appearance, and whether it will delay your funeral. The doctors are entitled to assume that any consent you gave was free and informed, unless they're aware of evidence that it wasn't free and informed. Your consent or objection must also be specific about the particular type or types of use it relates to, for example, donating organs for transplants or using your body or organs for medical research or both. Note, when the doctors remove organs from your body, they have to avoid disfiguring it unnecessarily. Human Tissue Act 2008, Section 54. The form of your consent or objection. Human Tissue Act 2008, Section 43. For your consent or objection to be legally valid, either it must be in writing, or if it's not in writing, you have to tell two witnesses who must be there together at the same time. So legally, you don't have to put your consent in writing, and if you do put it in writing, you don't have to have witnesses. But it's a good idea to put it in writing anyway, and to have witnesses when you sign this document. Your witnesses will be able to confirm later on for the doctors and others that you were mentally capable when you made the decision and that you had all the information you needed. Human Tissue Act 2008, Sections 9, 1A and 2A. Although legally you can record your decision in your will, the National Organisation Organ Donation New Zealand says that by the time your will is read, it will normally be too late to provide organs for transplant. So it's best to put your decision in a separate document that your family or friends will have access to, not in your will. Dealing with the deceased property. Wills, intestacy and small estates. Introduction. Whose job is it to deal with the deceased property? This is done either by the executor, appointed under the deceased will, or, if there's no will, then normally by a close relative who's entitled to benefits from the deceased estate under the laws of intestacy, the laws that say who a person's property goes to if they didn't leave a will. The close relative gets formally appointed by the courts to manage the estate and is then called the administrator. Personal representative is a general term that covers both executors and administrators. In other words, it refers to whoever is doing the job of managing the estate, under a will or not. But in this chapter, we'll use the combined term executor, administrator, rather than personal representative. This part of the chapter includes information about dealing with the deceased will, as well as what happens when there isn't a will. So find out about making your own will and how the directions in your will might be overridden in some cases. See the Wills chapter. What property does the deceased's estate include? The deceased person's estate is all their property, including their personal possessions like clothes and jewellery, money in bank accounts, any house or other land they own, called real property, proceeds from insurance policies and shares in companies. The deceased's estate won't include any property that he or she owned jointly with a partner, like a house. Because they owned the property jointly, legally this is called owning as joint tenants. This means that when one of them dies, the other becomes the sole owner. This is different from owning property together as tenants in common, which is where you each have a separate ownership share that you can pass on under your will to whoever you choose. And note that although these technical terms refer to tenants, in fact they're about ownership, not about renting or leasing property. What tasks will need to be done? The executor or other person dealing with the deceased estate will need to apply to the courts to get approval to deal with the property, either by getting approval for the will, called probate, or if there's no will, by getting appointed as the administrator for the estate. But court approval isn't needed if it's only a small estate. Get the deceased estate ready to distribute to the people entitled to it by identifying all of the deceased property, dealing with any claims that someone might have against the estate, for example, a relative left out of the will, and paying any taxes and debts that might be due out of the estate. Then distribute all the remaining property to the people entitled to it under the will or under the rules of intestacy. Those tasks are all explained in the sections below. Getting court approval to deal with the estate. Note: you don't have to get court approval if the property in the estate is less than a certain amount. See below. Small estates, no need for court approval. Applying for probate if the deceased left a will. If you're the executor appointed in the deceased will, you should first make sure that you have the latest will. You should also find out about and locate any changes to the original will, called codicils. Contact the deceased lawyer if they had one, or the public trust. You will need to apply to the High Court for it to approve the will as valid and to approve your power to deal with the deceased estate as the executor. This is called getting probate for the will. When you apply for probate in the High Court, the application will need to be supported by an affidavit, a sworn statement, and other documents, all in the form required by the High Court's rules. Usually the paperwork for the application will be prepared by a lawyer acting for the estate, and the executor can then complete the process and file the application with the court. If someone claims the will is invalid and changes it in court, the process is more complicated and involves a High Court trial. In that case, a lawyer will usually be needed to represent the deceased estate. Once the High Court has made an order granting probate or granting letters of administration if there's no will, the order becomes part of the public court records and anyone can look at it, along with the will if there was one. Note: if the deceased owned a house or other land, a probate order from the courts or letters of administration, if there's no will allow the house or land to be transferred to the beneficiary who's entitled to it. Legal ownership will first be transferred into the name of the executor or administrator of the estate and then transferred to the relevant beneficiary. Getting court approval when there is no will. Intestacy. If there's no will, the closest relative or a trustee company or public trust can apply to the High Court for an order entitling them to deal with or administer the estate. The order is formally called letters of administration. The person given authority to deal with the estate is then called the administrator. This process will also be necessary if the deceased left a will but it's invalid or didn't name an executor, or if the named executor is unable or unwilling to act. For example, they may have since died or moved overseas. If the deceased didn't leave a will, they're said to have died intestate. In these cases, there are special rules called the rules of intestacy that say who their property will go to and in what proportions. See below in this section, distributing the property, who gets the property if there's no will. The administrator appointed by the High Court performs the same duties as an executor under a will. Personal representative is the general term used to refer both to executors and administrators. Note: to make sure your spousal partner has an income after your death while they're waiting for court approval for your estate to be distributed, it's a good idea for you to plan ahead together by establishing at least one joint bank account. Any property, including money, that is owned jointly passes when one person dies to the surviving joint owner. This means that all the money in the joint account will immediately belong to your partner when you die. Small estates, no need for court approval. Court approval not necessary for amounts under $15,000. Administration Act 1969, Section 64 to 65, 82A, Administration, Prescribed Amounts, Regulations 2009, Regulation 4. If the estate is a small one, it may not be necessary to apply to the courts for approval to deal with the estate. Probates for a will or letters of administration if there's no will. Banks, company directors and so on can transfer or pay the following to the executor, administrator or to the family members or the beneficiaries who are entitled to it without any need for probate or letters of administration. Money in the bank, accounts up to $15,000. Shares worth up to $15,000. Life insurance policies up to $15,000. Government stocks up to $15,000 and local authority stock up to $15,000. The executor administrator or beneficiary will usually need to provide a copy of the death certificate. In these cases, the person or organisation paying or transferring the money or other property must also be satisfied that probate or letters of administration haven't been granted. Note, even if court approval isn't needed because it's a small estate, the executor has to follow the directions in the will, and if there's no will, the rules of intestacy saying who is entitled to what property are still binding. Arranging your bank accounts in advance to take advantage of the small estate rules. It may be possible to rearrange your finances before you die so that your estate comes under the special rules explained above for smaller estates. If, for example, you had $16,000 in one or more accounts with the same bank, you could transfer some of this money to an account with a different bank so that you now have less than $15,000 with each of the two banks. This will avoid the cost and time involved in applying to the higher court to get probate for your will or letters of administration if you don't have a will. Identifying and getting in all the property. After you've got formal approval from the courts to deal with the estate, you'll need to do the following things. Identify all of the deceased assets. Identify any people who might make a claim against the estate and try to settle these claims if appropriate. Gather in all the assets and get any necessary valuations. Pay any debts the deceased had. Pay any taxes due on the estate. Identifying the assets. The executors have to make sure that they know what all the assets in the estate are, including any overseas assets. If this information is not readily available, they will need to go through the will maker's papers and to talk to relatives and other people who had information about possible assets. They will need to write to the banks where accounts were held, insurance companies where policies were held, share registries and other organisations as part of that identification process. Note, if the will maker owned a house or piece of land jointly with another person, then that house or land will not form part of the will maker's estate, but will become the surviving person's property by virtue of the legal rule called survivorship. Land in two or more names is not necessarily jointly owned. The same applies if a person dies intestate. A lawyer will need to help the surviving person transfer the property into their sole name. The survivorship rule also applies to other jointly held items such as bank accounts. See below in this section. Gathering in all the property. Once the court has granted administration, the executors or administrators will need to show the court order to banks, insurance companies, share registers and anyone holding or responsible for any assets of the deceased person before those organisations will release the property to the executors or administrators or deal with them. This includes dealing with any assets that are held overseas. The grant of administration will also have to be produced to the Land Titles Office together with a transmission so that any land can be transferred to them. Once these steps are taken, they will then be able to deal with the estate's assets. There are special procedures about administration where overseas assets are concerned. Paying debts and tax. The executor administrator must make sure that all the debts owed by the deceased are paid. It may take some time to establish what all the debts are. File tax returns and pay any tax owed by the deceased up to the date of death and any tax for any estate's income earned subsequently. They must ensure all tax liabilities have been paid or allowed for before paying out the beneficiaries. Dealing with any claims against the estate. It's possible that a will may be challenged as invalid, or that someone may have a genuine legal claim against the deceased estate. For example, a family member may have been left out of the will and so could have a valid claim under the Family Protection Act, or perhaps a neighbour who regularly helped the deceased had been promised something but didn't get it, and so could have a valid claim under the Law Reform Testamentary Promises Act. If so, the executor administrator will have to resolve these disputes before they can distribute the assets of the estate. For the different ways in which people can challenge a will or otherwise make a claim against an estate, see the Wills chapter under Challenges to Your Will After You Die. Distributing the property. Once you've identified all the property that the deceased owned, have gathered it in and have also dealt with any debts, taxes and legal claims the deceased might have been responsible for, you can then distribute the property to the people who are entitled to it. You'll follow the instructions for this in the deceased's will, or if they didn't have a will, you will follow the special legal rules that exist for these situations called intestacy. Distributing the property under a will. The executor distributes the deceased property to the beneficiaries according to the directions in the will. Who gets the property if there's no will? Administration Act 1969, Section 77. The law sets out an order of priority for who gets the deceased property if he or she didn't leave a will, and in what proportions. All those people are family members. The basic order of priority is the spouse, civil union partner or de facto partner, then the children, regardless of whether the parents were married, the deceased parents, brothers and sisters, grandparents, uncles and aunts. Note, a de facto partner will usually only be entitled under the laws of intestacy if the relationship was for 3 years or longer, but there may be an exception if the de facto partner had made a substantial contribution to the relationship or there is a child of the relationship. Here are some common examples of how property is distributed under the rules of intestacy. Administration Act 1969, Sections 77, 82A, Administration Prescribed Amounts, Regulations, 2009, Regulation 5. If there's a spousal partner and there are also children, the spouse partner takes all the deceased personal possessions, including cars, furniture, appliances, jewellery, and so on. Basically, everything other than land, buildings, and money, plus a set dollar amount, which is currently $155,000, plus 1/3 of the rest of the deceased property. The children take the other 2/3 of the rest of the property. If there's no spousal partner, the children take everything in equal shares. If there's no spousal partner and no children, the deceased parents will take everything. If there's no spousal partner, children or parents, the deceased brothers and sisters take everything in equal shares. Note, if there's a family court separation order in effect, see the chapter Relationships and Breakups. The surviving spousal civil union partner doesn't have any right to the property under the laws of intestacy. However, if the couple were living apart but there was no separation order, their rights under the laws of intestacy are the same as if they'd still been living together. Administration Act 1969, Section 77A, Family Proceedings Act 1980, Section 26. If a person dies without any of the specified list of family members surviving, their property may pass to the government. Administration Act 1969, Section 77. Can someone challenge how the property is distributed when there's no will? Yes. People have the same rights under the Family Protection Act 1955, the Law Reform Testamentary Promises Act 1949, and the Property Relationships Act 1976, as they have to contest the distribution of an estate under a will. See chapter Wills under Challenges to Your Will After You Die. How long will it take for the estate to be distributed to the beneficiaries? As a general rule, most estates should be able to be finalised and distributed within 6 months after the grant of administration. However, this is very much dependent on the type of assets in the estate, any legal complexities, the terms of the will, and whether anyone challenges the will. If the assets are all in cash or can be turned into cash quickly, and there are a small number of beneficiaries and all liabilities have been identified and are able to be paid from available funds, then it may be possible to make interim payments before the estate is completely finalised. If the terms of the will are more complicated, it may not be possible to pay any of the beneficiaries until all the assets have been gathered in. If there are overseas assets in the estate, these may take longer to deal with because the procedure regarding administration in other countries can be complex. Maori land. Succession. Transfer of Maori land when an owner dies. An order from the Maori Land Court is necessary to transfer the deceased land interest to his or her successors. If the deceased owner made a will, any successor named in the will must be a member of the whanau or hapu associated with the land. In the terms of Te Ture Whenua Maori Act, they have to be within the preferred classes of alienees. People outside that whanau or hapu may be entitled to a life interest in the land or a right to income from the land only. If there's no will dealing with the deceased land interest, an intestacy, Te Ture Whenua Maori Act sets out rules for which whanau members the land will go to. For more details about those succession rules, see the chapter Maori Land under Succession Transfer of Ownership when an owner dies. This section also explains how to apply to the Maori Land Court for a succession order. Decisions at Tangihanga about Maori land. Te Ture Whenua Maori Act 1993, Section 176. Whanau at Tangihanga can make decisions dealing with Maori land, and the decision can then be confirmed by the Maori Land Court. For example, if a father of a whanau dies, the whanau may decide to create a whanau trust in the name of their father. See the chapter Maori Land under Methods of Managing Maori Land, Trusts, Incorporations and Reservations. They will need to record the decision as a resolution along with details of who attended. Other decisions that a whanau group at the Tangihanga might make are, for example, to become a Maori incorporation or to replace a trustee of an existing whanau trust. Again, these would need to be confirmed by the Maori Land Court. Financial support for bereaved families. Overview. Who can we go to for financial support? If the deceased family or whanau can't afford to pay for the funeral or tangihanga, they'll need to go into their local work and income office and apply for a grant. If the death has been brought about by an accident, ACC can provide a range of payments, including funeral grants and survivors grants for the partner and children. Whanau may also be able to access other funding through their iwi organisations or other sources. Funeral tangihanga costs. Who can provide funding for the funeral or tangihanga? You may be able to get help for the costs of the funeral or tangihanga from the following sources. Social Security Act 2018, Sections 90 to 94, Social Security Regulations 2018, Regulation 55. Funeral grants from work and income. If you can't afford to pay for the funeral or tangihanga, you may be able to get up to $2,128 from work and income to cover the cost, including for preparing the body, for example embalming, the coffin, newspaper notices, the hearse, and the cost of the burial plot or cremation. Accident Compensation Act 2001, Section 69, Schedule 1, Clause 64, Funeral Grant from ACC. If the death was because of an accident, ACC will pay a funeral grant of up to $6,311. Families of murder or manslaughter victims qualify for up to $10,000 towards funeral and memorial costs. Contact ACC or you can apply online. Help from your iwi. Maori may be able to get a grant for tangihanga from their iwi organisation. Maori can also seek tangihanga funding from Maori land trusts or organisations in which they or the deceased have an interest. See the chapter Maori Land under Methods of Managing Maori Land, Trusts, Incorporations and Reservations. To find out about other possible sources of support, contact Te Puni, Kokiri or your local marae or Maori church. Ongoing income support and some one-off payments. Ongoing income support from work and income. If you don't have any income, you can apply to work and income for an ongoing benefit. The type of benefit you might qualify for will depend on whether you have children and how old your children are. See the chapter Dealing with Work and Income. Death by accident. Support for the family from ACC. Accident Compensation Act 2001, Section 69, Schedule 1, clauses 65, 66, 70 and 76. If the death was caused by an accident, ACC will provide a range of ongoing or one-off support for the surviving partner and children. Survivors grants. ACC will pay a one-off survivors grant of $6,766 to the deceased spouse or partner and $3,383 to each child under 18. Weekly compensation for spouse or partner. This is paid at 60% of the rate the deceased would have got had he or she lived but been completely unable to work. These payments continue for 5 years or until the children are all 18, whichever happens first. The payments won't be affected if the surviving spouse or partner remarries or gets a new partner. The weekly compensation can be converted to one or more lump sum payments. Weekly compensation for children. This is paid to each of the deceased children or other dependents at 20% of the rate the deceased would have got. The payments continue until the children turn 18 or 21 if they are studying. Childcare. ACC will pay childcare costs for each of the deceased children. The payments continue for 5 years or until the child turns 14, whichever happens first. Note, if you lost a family member in the Christchurch mosque shootings in March 2019, you may be eligible for some support from the government. See the Accident Compensation chapter for more information. Euthanasia and assisted dying. Overview. Assisted dying is currently a criminal offence. Crimes Act 1961, Section 179. Helping a terminally ill person to end their life is currently a crime in New Zealand. It comes under the offence of aiding and abetting suicide, which makes it illegal to encourage or help someone to commit suicide. You can be jailed for up to 14 years for this if the other person does in fact end their life or tries to. If they don't commit suicide or try to, it's still a criminal offence, but the maximum penalty is a 3-year jail term. Euthanasia to become legal in New Zealand. The 2020 general election on the 19th of September 2020 included a referendum on assisted dying. The End of Life Choice Act 2019, which gives people the option of asking for assisted dying, was passed by Parliament and would only come into legal force if more than 50% of voters supported it in the referendum. The referendum results revealed that a majority of voters supported the law coming into force. The End of Life Choice Act will come into force in November 2021. And that concludes the first chapter in the Community Law Manual, A Death in the Family. Apologies for any mispronounced English or te reo Maori words. This is Helen Hotai, founder of Form Help, signing out. Have a wonderful day, everyone.